Detective Guth is coming off the witness stand, and the only available witness for Brooks to call is Erika Patterson. Welcome back, everyone, to day 12 of the jury being present in the Waukesha parade attack trial. I would say that time is running out for Darrell Brooks, but let's face it, time is really all he has, isn't it? He wants his one-on-one questioning of Erika, but only on his terms. However, he gets a fair trial, and really isn't that more than enough for this man who has already taken so much from those around him? It may not be the 4th of July, but the fireworks on this day in Waukesha were heard by everyone. So let's get to it.
Call your next witness, please.
Is there only one witness left?
Yes. For that, yes, for that time. Yes. I believe.
No one else is here?
No, it's not 10:30 yet.
Who's supposed to come in 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me jot it. I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Thank you. While we're doing that, if the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
I set for value in return for value this paperwork.
Thank you. If everyone would have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. If there's a witness available, please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 906.11, I have the authority and the discretion on that, so please call the witness who's available.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time, being that this is my time.
Right, I'm going to excuse the jury for right now. I'll rise for the jury, please.
I wish I knew what Zach said to Leslie there.
All right, thank you. Be seated. Mr. Brooks, under 906.11, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
so.
no. You
Here's
can't.
the
That's
thing.
a rush to
Erika
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her. She's on your list. She was on the listing as I understand it, the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking the
your
question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of witnesses.
why is it always so hard to just say yes or no? Is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
you told
fine.
me your
Your
authority.
objection
I'm
is
not
noted on the
debating
record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with the
You
last?
said you wanted to
I
raise
said-
an issue with about
What
Detective
I said
Guzman's
was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And so then I asked you
Your Honor,
to put
with
him
all
in
respect,
flux.
with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I have
times.
authority to tell you otherwise. You may not like it. You may
I did.
disagree with it.
It's not about that. It's about the rush to judgment,
You have not been
Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They volunteered.
They offered.
So at the end of the day,
but we expect
if they didn't want to do it, yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor.
No, common courtesy is the stipulation.
Okay,
sir.
but it wasn't stipulated to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you
in a trial,
you can't put the people in a specific spot for me, Your Honor. Come on now.
It is.
That's a rush to judgment.
There's no rush to judgment here.
Did the state have to put their witnesses? Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be provided with. We're going to call this witness at this time.
But they're
this
able
witness at this
to
time.
contact their
They didn't have to
witnesses
do that, so why should I have to do that?
and accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses.
It's about what's fair. It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
here's the
with a shock device on my ankles.
9:52.
So how's I'm trying to control anything? I just want this to be fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me how that's fair.
The process that has been set up to, frankly, help you.
No, it's not helping me it's helping the state by being able to say, if we know the time and we know the person and we know this, then we can be prepared. So we'll already be ready.
Mr. Brooks,
that was the whole aim of that.
And I would have had her come in later. You didn't want to answer that question.
There was no question. There was no question to answer. I did what you asked me to do, Your Honor. You said,
you didn't.
Yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't going to be prepared to do their
here's the deal. The jury's coming out, and I'm going to stand my ground on this.
I'm going to stand my ground too, but I'm not going to be disrespectful or disruptive. I'm just stating I want it to be fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that. Where's the lawful law? Where's the lawful law? I have the right to witnesses.
You have to cooperate with this process,
but I also have the Sixth Amendment right.
We have a witness available for you to call. I can require you to call her.
It's not the witness that should have been called at this time, Your Honor.
It is based on the list that you provided and
that didn't have a time. That didn't have a time or of
I'm not going to play
order.
This game with you, sir.
It's not no game. That's what you don't seem to understand.
I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
But there's
and it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I think, Your Honor, with all due respect, I think you should show some respect.
We're going to take a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about. You a public servant.
See how he flips the argument around, and he always has a backup argument about something else, just in case he needs to pivot.
After a short break, appearances are as they were before. I would just note Attorney Opper's not at the table, but I presume she'll be back shortly. I will be advising the clerk to have the jurors brought out, and then I'll ask you, sir, to call the defense next witness.
Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so. Your objection is noted.
Is the audio on?
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record?
For the record, I have addressed it.
No, you haven't
And
proven it
here's
for
your
the
written,
record.
and your objections noted for the
Have you
record.
proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it?
Oh, okay. Email that to her and print it out.
So that's your judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in. You
heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Be here 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment. That's not right. Oh, there you go.
Has anyone ever noticed how he flips and organizes his papers? It makes no sense. Just shuffling to shuffle, trying to look important, like a child playing office.
All right.
Go ahead.
Defense calls Erika Patterson.
Thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my colleague Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erika Patterson.
Thank you. Go ahead, your witness.
Are the one spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
Erika Patterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here. One second. I'm sorry about that. 1 second, I'm trying to find this paperwork. Just had it on the table.
When you're ready.
This paperwork.
Did you print that off for me? Did you email it?
Still not here. What's your name?
Did you stop?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. Good morning, Miss Patterson.
Good morning.
So, what do you do for a living?
I have my CNA certificate.
I'm going to direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
Oh, I was referring to the judge.
I was hanging out
I
with
think
Miss
I kind of
Corey.
got a little ahead of.
Mr. Brooks, just I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead. Ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
We covered this ground during her testimony previously.
Objection. And grounds for, I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's with the
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Is that usually the name you refer to the alleged defendant by?
Nope.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park, and she went her other way with her friend.
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up?
Yes.
Well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went out, it's a street, it's like a hill. We went out there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering your question. You asked her where you drove from. Go ahead. Finish.
Yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park, and you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time sorry. Did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
And did you ever arrive back at Frame Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me some more. I walked back across the street, and by that time, Miss Corey had already walked toward us to meet up with me.
And you made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemails, and I called Nick's phone. He put Corey on the phone. I said, Darrell Brooks had just hit me.
I want to back up a little bit, if I may, to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection. Move to strike the answer and the question.
Grounds.
Lack of personal knowledge. Hearsay.
Sustained. I'll strike the question and the answer for the reason stated, serve, rephrase, or...
So can I show the witness the same paperwork that I attempted to show?
No.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Some facts not in evidence. Sustained.
Grounds for the sustain.
The record speaks for itself.
So, upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright. I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. Till the next day, Mr. Brooks.
Right here would be a great time to flash back to his interview with law enforcement and the abundant amount of lies he told.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
By my lip.
Objection. States the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents from November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
Well, 1 second. So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Was it morning time?
Afternoon.
I didn't hear that.
Afternoon.
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Since facts not in evidence, it characterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting.
You've been sitting there the whole time. Nobody took anything from your table. Probably got lost while you were playing fake office.
So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Is that the only child in common?
Yes.
You have any other children?
Objection.
It has
Grounds.
nothing to do with the case. Sorry.
Hold on.
I'm
There's
sorry.
been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How's it not relevant?
Next question, please.
How's it not relevant?
That evil smile he gets from being mean to Erika.
The child that you have in common with the alleged defendant. How old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained. It's not relevant, sir.
She answered it.
Next question, please.
Do you keep contact with all of yours, Brooks? Don't you have 3 to 5 fatherless kids out there?
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds?
Relevance.
Sustained, not relevant. You don't have to answer that.
Do any of your children live with you?
Objection.
Grounds?
Relevance.
Sustained.
Grounds for the sustain?
Not relevant.
That goes to the credibility, Your Honor. So how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question, please, sir.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I don't remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming, that would mean no contact at all via phone or anything like that?
No.
No matter how many times you've tried to call her.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them.
Look at Sue's face when he did that.
I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. It's not proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do.
Sustained.
I'll get into how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Fact, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and at this
facts.
point,
I got the pictures right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, the dates that are charged for these allegations, you are absolutely correct.
Thank you.
I think his mother mailed those to him. Zach will be calling it all out in a moment here.
Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury.
He's trying to make her look bad, but it bites him in the butt.
Thank you. Be seated.
It's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you need to have
Do you
contact?
want to open up the door to the other act's evidence of...
That's not opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts of evidence between you and this witness. And I've been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence.
That is true.
No,
she said it herself.
No, marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got to.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I want you to make a record.
Procedure.
If you don't make a record,
so
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you aren't
stop
even
it. You're a public
me
servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I come back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Upper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here, and now all of a sudden I can't.
And now you're impugning, though, like somehow you're imputing the integrity of this court,
No, I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
something?
record without you
Yes,
interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't sign my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well,
I
that's
think
kind of
that's fair.
interesting. I don't
think
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures. Because I thought from My interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air.
I call BS.
The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing. And oh, this and this and that. Oh,
I don't think
no,
she's ever
still love
said
you.
she was afraid. I think that was the officers who may have stated that. But I don't believe she
But
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes. And she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate to
Honor.
her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erika Patterson?
Because they were sent from Erika Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you
content of the
kidding me?
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on the limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is going to... When you
You're
say
not
to
answering my
me, when you say to
question,
me,
sir. What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in
serious?
jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming.
Like how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. or-
Once again, you're doing this tactic.
Because
You try to
it's not a
go
tactic,
off
it's
of what we're
facts.
talking
It's
about
facts.
to some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from...
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
Okay, get ready, guys. Here it comes.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erika Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erika Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erika Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erika Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore
to that.
I'm not
because that's a lie.
Let him
because at
finish.
the end of the day,
Let him finish.
If we're gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was. when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he can show it is inadmissible, she will not be questioned, and under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Oh, did we hit a sore spot?
All right, thank you. Be seated. The record should reflect 12:10. I do have Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. We are on day 15 of trial, and today has been a rough morning, to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very best to honor his rights in that regard. Part of this morning dealt with his, from my perspective, disagreement with how I, yesterday and in the days preceding that, set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly my obligation under 906.11, to make sure that there is an effective presentation of evidence, and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial, or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I have done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury, to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erika Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder. He got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped and basically looked at me and can I answer that question, basically? Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erika Patterson, and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on 2 separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally 2 of the statutes dealing with character evidence. That would be 906-08. 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erika Patterson, and then the photos. The issue, as it relates to this witness, is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erika Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him, related to the other act's evidence, related to whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative. But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong. That needs to include an offer of proof as to why he believes this letter is from Erika Patterson and why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system of this trial. There was nothing dignified about it. There was nothing orderly about it. I would remind him once again of SCR Chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily. An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? 7th. October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
They probably lost an entire day's worth of trial with the delays from Erika testifying.
Back on the record, I've been advised that Mr. Brooks does not want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom. It is my sincere hope that you want to come back here. I see you're reading something, but we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. And I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom.
He's reading instructions on how to build a box fort.
I've been advised he can hear and see. Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
Are we supposed to be back on the record?
Yeah. She's asking a question.
The audio is on. Would you like to come back to this courtroom, sir?
Unmuted.
You're unmuted.
So I'm finally unmuted.
You've been unmuted for a while. Since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
The audio to that courtroom is loud. We heard her echoing earlier. But he is going to continue playing games with the headphones.
Record to reflect, he's putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
All right, are you ready to come back then?
Not if I'm just going to get held in contempt again.
I didn't hold you in contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption, pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever going to get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're going to hold me in contempt.
Sir, I need to continue with the trial. So if you don't answer yes or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held.
failing to answer my question, sir. So I'll ask you again.
Are you going to hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not going to hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name. Yeah, I'm always muted. I don't know why she think I can hear everything she's saying perfectly clear without the headphones. Oh, that's a trick to help hold everything up too, right? Ain't gonna do nothing but hold me in contempt, man. I might as well stay over here. Thank you.
Record, it's 12:48. All right, let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof to provide, sir?
We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof related to
I just said no. I just said no. I just said that.
All right, thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
I guess I'll have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I'll tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics. And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today. What new topics will you be?
I don't remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already covered.
What, pursuant to the police report or something? Is that what you're asking? No, I don't understand.
I'm asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say it related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only...
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here.
Do you see a written statement with her signature on it?
I'll have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No, Your Honor.
It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barron wrote that first report. Those interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about so I know with specificity?
Oh, I'm looking at it now.
He has nothing relevant to the case to ask her at this point, but he's going to drag this out as much as possible.
How many officers did reports? Because it seemed like it's more than just 2. At least from this paperwork, is more than 2.
May I have a bailiff show me what Mr. Brooks is referring to? I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there.
That's the first time I noticed that. He accuses the bailiff of snatching the paper away. Let's watch again.
I can't find the first page to that, but whoever that officer is right there.
So I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047533. This is one of the 2 reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what questions, what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the question.
Under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand, what do you mean by closed?
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
First of all, the report isn't even in order. So I would have to essentially read at least some of it to even ask
Mr. Brooks, this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out. The jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I have to do that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's.
So I'm being held in contempt again?
No, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your right to be present.
I might as well have just stayed over there.
No such contempt finding.
I might as well have just stayed over there then if I was going to get held in contempt.
That decision is for you and you alone to make, and it is based on your conduct If you're going to
Just
continue,
take me over there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did. You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being held in contempt?
I'm going to keep you in here because
that's the whole reason I didn't want to
call
come.
the next witness, and I'm going to need to bring you over in any event.
That's the whole reason why I didn't want to come over here because you was going to find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive outbursts.
Well, then remove me if that's what you want to do. Remove me then.
I don't want to do it, sir.
Obviously you do.
This courtroom.
Obviously you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even though it will be short.
Did I actually forfeit that right?
You have forfeited your right to be present.
And how did I forfeit that right, Your Honor?
All right. We're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in contempt.
Then what did I do?
All right, I'm going to step off. You've interrupted repeatedly. I'm going to step off. Please be seated. Madam Clerk, would you please have the jury brought out and make sure all the monitors are on? You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction when I was over here?
I'm going to mute you if you do that, sir.
I'm not going to do it when the jury. That's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record? Will I at least be told why I'm held in contempt when I didn't do nothing? Civil or criminal?
That's a misstatement of what I did, sir.
So why am I over
I will
here?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
You're going to mute me anyway.
Not if you're quiet.
So I got to be quiet like a little kid?
It's not what I said, sir. You have to be respectful. You have to be respectful of the proceedings.
But nobody has to be respectful to me, though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen them through the TV screen and made me feel uncomfortable?
Jury's coming in. Please rise for the jury.
So that's not going to be addressed. Okay?
Mr. Brooks, I'm muting you.
Middle District of Pennsylvania.
Oh, okay.
It's the federal district. That was appealed.
It was later affirmed. Okay. Can I have the preliminary instructions for a second? Oh, sure. I should just keep them. They're nearby. Thank you, everyone. Please be seated. Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. Thank you for being here. All right, the defense may call its next witness, please. Go ahead, sir. You can call your next witness.
was muted.
You're not muted.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly. All rise for the jury, please. All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
So what's going on now? Now am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will. He's interrupting me once again.
Okay, you talking. You're the one talking right now, so don't do that.
I'm going to mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because, number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay, he is again not answering the question directly.
Don't try to put on. Don't.
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I've done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he is continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've made a record of that, sir.
I have to answer everything, though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because, frankly, you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic. Mr. Brooks.
A delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I will... Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones. You choose
because
to read.
I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The muting is so that I don't have to hear the disruptions.
Okay, well, then why should I need to hear what
So
you
let me be clear, sir. And you are
gotta
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again? We gotta keep doing this little childish stuff, dude.
His mind is so warped, he thinks she is being childish.
I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks is spouting off, making unsubstantiated allegations against this court, directly attacking the integrity of this court and these proceedings, while yet refusing to answer simple questions. Mr. Brooks,
That's not my name. I told you I don't consent to being called that name.
Sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or you will forfeit your right to present any additional witnesses.
Show me where that's law.
Because you are not cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks.
How can I forfeit not being able to have a defense? Are you kidding me?
All I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will gladly bring you back into this courtroom so you can present your additional witnesses. But you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question.
Now he pivots to not understanding.
I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal. You can raise that issue on appeal if you are convicted.
This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law.
Then he circled around to not being able to see anything in the courtroom.
I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
Sir, it's a yes or no question. Would you like to come back into this?
Well, my answer was based on the reason why I was answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth.
Then shut the fuck up.
It makes essentially it wastes time, really.
I'm well aware of that, sir. That it delays the proceedings.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct that's I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine.
And you have demonstrated throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So you clearly read, write, and understand English. That's not an issue here, sir.
It's not fair.
Are you self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to represent yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do so at your peril.
That's not fair to state, Your Honor, because...
So I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over, or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record, and he will come back over here. Thank you. We are in recess until that happens.
Let me know.
you back over there if you want.
I mean, just to say something and then get kicked out.
I don't know.
Man, I don't know what to tell her then. So
She's taking a break right now. Wants us to take you back, have you go back.
no, because I'm gonna end up having to come back over here. And don't y'all get tired of hauling all this stuff over here, over there, over here, over there, over there?
The record should reflect that Mr. Brooks is present in the courtroom in person and in custody wearing a suit and tie. Actually, his suit coat is off, but he's still wearing a mask. And the jury will be brought out, and you'll be asked to call your next witness.
Being called that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
So now we are back to subject matter jurisdiction. Do you see what I mean about the circle of blockades he throws up?
Thank you, everyone. Please be seated. The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
Let's go with Dianna Aldrich.
Dianna Aldrich? All right, very well.
I'm sorry, Your Honor. I think she was in the other building, so.
That's all right. Thank you for letting us know. Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Come up and have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay. Dianna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV?
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
description-wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down,
yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Calling a witness who didn't have her glasses on. It's comical.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was. And they were going to walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks?
Yeah.
Do you recall how many people there were?
Maybe 10.
The prosecution thanks you for confirming the vehicle wasn't tampered with, Mr. Brooks.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
If you recall, did you Did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, which street did you say?
Arlington.
Arlington. I apologize. Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Do you recall the name of the officer that interviewed you?
No.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
This is a good stopping point for this video. He still has a few more witnesses on day 12 that we will get to in the next video. See you then. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.